Hello and welcome to Lunchtime Politics, reaching you live from our global headquarters here in the nation's commercial nerve center, Lagos. I'm Jeffrey Uzonga. Let's bring you up to speed with the big happenings in politics and in the polity right now. Rain of insults and counter-reaction between Senator Peter Nwebonyi and former Minister of Education Obieze Kwesili during the Senate Ethics Committee hearing over sexual harassment allegation against Senator Godswill Akpabio by Senator Natasha Akpoti-Uduaghan. The Independent National Electoral Commission says petition to recall Senator Natasha by some Kogi Central constituents did not meet requirement. Thanks again for joining us on the program. And of course, there's a lot going on in the polity, and we'll bring you up to speed with everything as far as this is concerned. At midday, we call it your all-access pass to what happens in the polity, and especially in politics in Nigeria. The tracking of the polity begins from the response of the Independent National Electoral Commission explaining how the petition to recall Senator Natasha Akpoti-Uduaghan from Kogi Central did not meet what they consider requirement for the action by the commission. The commission acknowledges that the petition was accompanied by 6 bags of documents which contained signatures from over half of the 474,554 registered voters spread across 902 polling units in 57 registration areas, that's wards, in 5 local government areas of Adavi, Ajaokuta, Ogori, Mangono, Okei, and Okene. However, in a statement, the Commissioner and Chairman of Information and Voter Education, Mr. Stam Lumelekun, said it noticed some missing pieces in the petition as representatives of the petitioners did not provide their contact addresses, telephone numbers, and email addresses in the covering letter forwarding the petition through which they can be contacted as provided in Clause 1F of their regulations and guidelines. The statement further says once a petition meets and complies with the requirement of the submission by law, it will announce the next steps in line with extant laws, regulations, and guidelines. Now, the Senate Committee on Ethics and Privileges has officially dismissed their sexual harassment petition filed by Senator representing Kogi Central, Senator Natasha Akpoti-Uduaghan against Senate President Godswill Akpabio, and adjourned the case in a day. The chairman of the committee, Senator Naida Imaswen, made the declaration when counsel to the petitioner, Dr. Abiola Akide Afolabi, appeared before the committee, that's the Ethics Committee. The counsel was accompanied by a former Minister of Education, Mrs. Obieze Kwesili, alleged bias and lack of fair hearing by the Senate Committee. Our National Assembly correspondent, Gloria Omezeke, has a report.
Barely 3 weeks after the suspension of Kogi lawmaker, Senator Natasha Akpoti-Uduaghan, counsel to the petitioner, appeared before the Senate Committee on Ethics, Privileges and Public Petition, led by its chairman, Senator Naida Imaswen.
In this regard,
during the hearing session, there is an initial hiccup as the counsel to Senator Akpoti-Uduaghan first calls for the recusal of the committee chairman, Senator Naida Imaswen, citing bias, particularly in the prior comment made on March 5, where the chairman had described the case as dead on arrival.
Until when we read that the rule of this House and that Constitution, that's when we can say that we have fair hearing and justice in this regard. In this regard, what the petitioner had said is that based on that press briefing, whether it was before Natasha was sent out of the National Assembly or not, gives an impression that the chairman of the committee has a particular understanding of this issue and could be said to be biased.
The chairman immediately defended his earlier comments, explaining why it was pertinent to dismiss the case.
From the position that I can see you are taking, it means the whole Senate is biased because the whole Senate witnessed what happened on the floor.
However, former Minister of Education, Dr. Obi Ezekwesili, who came as a witness to the suspended senator, described what transpired at the Ethics Committee as a gross degradation of the Constitution and the laws of the land. However, while she made her remarks, tension escalated and the atmosphere grew chaotic as a heated exchange erupted between her and Senator Peter Nubui.
I will not touch it. That is why you can never be here. People like you can never be here. People like you can never be here. Because I'm not a son. How can you be? How can you be of you? I'm not a hooligan. So I can. You are a hooligan. You are a hooligan. So you will be here. You haven't taught me. And you say I should keep my mouth shut. Who are you, Professor? Who are you? Are you the presiding officer? Who are you? I asked to be put on court. And you refuse.
Calm was later restored.
Two things. One, the petitioner said he would not speak to his petition because the Senate is biased, or I'm biased, or the committee is biased. Two, the respondent has just told us, and the papers are before you, that this case is before a competent court of law. Therefore, this committee will allow a court of law that will not be biased to handle this matter. Therefore, this matter is closed here at the Senate and is adjourned.
As the case stands adjourned, Sinadir and the parties aggrieved, it is unclear what the next line of action for the Senate will be. From the National Assembly, Gloria Umezuke, Channels Television News.
All right, away from that, let's also tell you what was happening next door at the House of Reps, where 39 amendment bills have passed second reading at the House of Reps in a lineup of bills cutting across various sectors, including the judicial reforms, electoral matters, security and policing, including governance, legislature, and more. Some of the proposals include amendment to the Constitution to provide for the establishment of state and local government police, general elections to the office of president, state governors, National Assembly, state houses of assembly, and local government areas of council to be conducted simultaneously on the same date to be determined by INEC in consultation with the National Assembly. Also to make the Court of Appeal the final appeal court in governorship, National Assembly, and State Assembly election petitions, as well as to provide for special seats for the physically challenged persons in Nigeria at the federal, state, and local government and legislative houses. Now, we have a lot of these bills, about 39 of them. You can go to channelstv.com and get a full breakdown. But let's bring in our guest, who is a senior advocate of Nigeria. He's going to be the core of our conversation, this amendment. Senior advocate Kayode Adiluola joins us virtually. SN, thank you so much for coming on the program. Ms. Adiluola, can you hear me, sir?
I can hear you now.
All right, fantastic. Thank you for coming on the program. So before we get to, in fact, when we get to the amendment of the Constitution, it's going to be some form of omnibus question for you to give us an omnibus answer. But let's talk about what has been the headlines in the past 24 hours. That altercation outbreak at the Senate hearing committee over the sexual allegation preferred against the Senate President by Senator Natasha Akpoti. And we saw all kinds of insults and counter reactions and all of that. We're already dealing with a situation where our institution is suffering from the crisis of confidence. Do you think in your books, knowing what you know about what has played out, this is even further worsening crisis of confidence in the system?
Thank you very much for asking. Crisis of confidence, to what extent and by whom, in respect of who? The citizens of the Federal Republic of Nigeria, of course, expect great performance from those who they have elected. They also expect them to serve the members of the public. They expect them to carry out their responsibility with diligence, decorum, dignity, respect, and honor. And they also expect that when things happen, whether on the floor of the Senate or in public, we are able to see that there is transparency. We're able to see that people have acted in the best interest of the electorate. Well, shall I call it the members of public and the citizens of Nigeria. Right now, a lot of people are asking questions. Some of those questions are legitimate. Some of them also are drawn from the scenario people have seen. Let's take it from the very beginning. A member of the Senate has reported that she has been sexually harassed, and a lot of people feel that's an allegation that is very strong, and people should be allowed to address it. If whoever has been accused does not present himself for scrutiny, such that we're able to determine whether he is actually in the wrong or right, then that will, of course, create a crisis of confidence in the people. Why is there no opportunity for the Senate president, for him, for example, to defend the allegation of sexual harassment? But then again, I will add that for sexual harassment, the standing order of the Senate itself says that you cannot bring to the Senate a matter that has a judicial remedy. Now, if you have been sexually harassed, is it a crime in our statute books? If it is, then the appropriate form, in my opinion, as a legal practitioner, is the courtroom. Let the Senate president have his day in the courtroom so that we do not have this roundabout way of coming to the Senate with a petition. It's signed by the petitioner herself, it's taken back, and they're done again. We don't want a circus. We want to get to the bottom of this and determine who is wrong. And don't forget, the truth is that sexual harassment is predicated on the jurisdiction in which it occurs. What you do in America, for example, which will make you liable to go to prison, may not necessarily be seen as one here. Sexual harassment, of course, has been defined by the UN as unwelcome sexual advances. And under our constitution, a woman or even a man has the right to have personal dignity and respect. And this has been taken away from any individual, whether it's senator or any individual. She has the right to seek redress. And unless a door is open for her to seek redress, people will think that it's something to cover up. And that, of course, will generate a crisis of confidence.
So just before I leave off on this particular issue of what's playing out in the Senate, I also want you to speak to the issue of the Senate rules and the place of the Constitution, a particular issue for me, which I would like you to speak to as a senior advocate of Nigeria. Section 60 allows them to make laws and procedures for their sitting and their rules and all of that. But the law in Section 1, subsection, I think 3 of the Constitution also talks about if there's any inconsistent by any other law against the Constitution, that law falls flat. I'm saying this to say that when it comes to suspending a senator for 6 months, this is how we process it. You may be punishing a legislator for an act based on the behavior of that legislator, but you have rendered a constituent voiceless for 6 months. This is not just to Natasha, but every other person who has been suspended. And then the issue of hostility to dissenting voices is also another conversation. The issue of the place not being safe for women because of patriarchy is another conversation. But I'd like you to speak to this issue of Senate rules versus the Constitution.
Now, Senate rules. Just as the Senate, an arm of government, has its rules, the courts also have their rules. And if those rules in any way infringe the constitutional right of a citizen, quite like you have already stated, those rules or regulations must give way to the superior provisions of the Constitution. Sometimes this situation may be resisted, but for us as a growing democracy, the best thing to do is to go to the courts and have the courts declare such rules or regulations null and void for being inconsistent with the Constitution. I do not think it should be a shouting match, and I do not think people should take laws into their hands. And I also do not think that the senator or any individual for that matter who has been wronged should simply attack the Senate. The courts are there to take us through the whole process and determine that this rule in particular is wrong. There was a time you couldn't appear before the Supreme Court if you were not 10 years at the bar. Somebody was bold enough to take that to the courts, and the court said that, well, that would amount to denying such a person fair hearing. And so, so we're in a process of development. Where things are wrong, let us seek redress. Where things are not clear, let us seek clarification.
All right, Senator Advocate, so let's talk about the amendment. In fact, as we're speaking, more amendments are scaling reading, second reading. In fact, let me bring you the latest. The one that has to do with, they are trying to qualify the immunity conferred on the president, vice president, governors, and their deputies in order to curb corruption. Also, a bill to alter the constitution to separate the AGF from the Minister of Justice, and then to grant citizenship right to spouses of women from Nigeria, specify the number of youths and women that may be appointed into specific offices. So I just wanted to bring you up to speed with the latest we just heard. But let's get back to the ones that happened yesterday. Let's begin with the issue of INEC now conducting elections for local government. I think that's going to be an alteration of Section 197 of the Constitution. If INEC is now going to conduct local government election, and then the Federal High Court is going to be the original jurisdiction for electoral offenses, no matter those elections, doesn't this negate the concept of federalism? This sounds like centralization. Or what do you think?
That's interesting. Yes, centralization in a sense. But we have seen how local government elections have panned out in the states where those elections have taken place. It has been almost a winner-takes-all situation. We don't want that. But the question is whether the elections are going to be conducted by INEC at the center, or the states will conduct these elections by the state electoral commissions. The question is, are we going to be transparent about these things? Are we going to be able to deliver to the citizens who are voters the results of their effort at going to the polling booths and voting? The INEC, I believe, has the capacity to conduct elections for all the 774 local governments. They have the capacity to conduct elections for the National Assembly, State House of Assemblies, as well as the governorship elections and the presidential elections. But the question is, are we willing to make use of the facilities available to us? When I say facilities, I mean beavers, IREV, the voting technology that the online voting technology that we should be having.
Let me say, if I may button, sir. Just a moment, sir. If I may button, in addition to your response, sir, I thought it's going to be an omnibus one. So in addition to that, there's the issue of conducting elections, all elections in one day. Presidential, state, local government, all in one day. I just needed to add that to your response.
Yes, I will add that to my response. You see, the point is, again, as I said, INEC must be able to demonstrate that they have the capacity to do these things indeed and in truth, and they will use and utilize all the available resources at their disposal for efficient election conduct of elections. As I said, the electronic voting that we have decided we should have, do we have people who are changing us or circuiting these things? Why don't we have results on IREV real time? We have companies, we have banks that have online transactions real time across the nation. It works. When you send money on MoneyPoint or Zenith, it works. We have LASU, for example, a university that has 3 campuses. When they have the union elections on 3 campuses, they do this from their various campuses online, and it works. Why can't we sit in our living rooms and vote with our BVN or a voter's cards and what have you? Why is it impossible? As a matter of fact, I'm going to say this to Jeffrey, that if in 2027 we still have problems with voting, electronic voting, IRF not working, beavers contradicting the number of voters, then the truth would then be that we are insincere. If we are sincere, these things cannot be rocket science. And if it is rocket science, can we please bring scientists from other parts of the world to help us get this thing done properly? Voting in 2027 just must be right. And as you have asked, voting on the same day for all elections. There's nothing wrong with that. We should be able to do that. Everyone should go to the polling unit so that you're not saying, oh, I will repay you for supporting me in the governorship election when you want to become president. Let us get these things done. But the truth is, INEC must demonstrate that they're sincere. I must demonstrate that the resources and the facilities at their disposal, they will use optimally. And at the end of the day, every result that comes out, we shall all accept as gospel.
All right, Senior Advocate, there are three more I would like you to speak to in quick succession. The first is, it is called the FCT for a reason. From my understanding, when Lagos was the capital of Nigeria, they had Lagos State, and then it was still serving as Nigeria's capital. They created the FCT from, I think, Niger and a couple of other states. It's a territory. Now, there's a proposal to amend the constitution to have a territory, which is not a state, to have a state, to have an assembly. What do you make of that?
Well, maybe we're slowly getting to the point where FCT will become a state and then we'll have 37 states. Maybe, just maybe. And the truth is, well, if the FCT, like you said, Lagos State used to be federal capital, and it was a state in itself. You had a governor and had its own council, and when we had civil administration, it had its own assembly. There's nothing wrong with FCT having those assembly. People who live in FCT should also have representation, and if they do, what then would become of the FCT minister? Would he bow to the assembly? Would he be willing to do so, or would he still continue to see himself as minister only?
Senior Advocate, as it is now, it's debatable. It is a territory, it is not a state. So to have an assembly is almost a misnomer. So we need a state before it can be an assembly based on our constitution. Is that what we're saying?
But there are Nigerians who live in that territory. Those people also live in areas, you have Nyanya, you have Apo, you have whatever. Shouldn't they have representation? Shouldn't they have people who should speak for them? Must they go to the Senate to have people speak for them? And when there's flooding in an area, should they call? And when there's discrimination against them in some areas, who should they speak with? Should they always go to the minister to beg for favors? I don't think so.
You know, it is the same concept that we have in the DC, in America, for instance. Anyway, let's move on to the other ones so that the time. I know the state police and local government police issue, but there's another one I would like you to speak to. Defection issues, they are now saying the amendment, and I like this part. It said before you defect, you must actually resign, not the confusion we had in Rivers State, that we saw defection and then we didn't see defection anymore. They say you must defect, you must resign before you say you have defected. And in fact, before you run, as a lawmaker now, according to this amendment and proposal, before you run for office, any office, state or local government or state or national, you must resign. Because if this was in place, people like Gospel Akpabio and Ahmed Lawan won't make it back to the Senate because they were still senators and you know what played out. So what do you make of this?
I fully agree. Now, the point is, if you want to defect, resign. By your resignation, it means there is documentary evidence of your resignation from that political party. Now, you'll not be sitting at the Senate, for example, without having a party forming the basis on which you appear before the Senate. So when you when you resign from a political party, you will then apply to another party where you'll be accepted, and the process was very clear in the new bill, in the new legislation, saying that not only should you have defected here, you should also have written an application to the other political party. The application should have been accepted. A copy of your party membership card should be issued to you, and so that puts pay to it. So we won't have a situation where people say that, oh, I resigned, but I didn't resign. Well, he's still a member of our party. No, he's no longer a member of our party. But you see, then again, we must think these things through. Let us determine when a person defects, should he lose his seat? Really and truly. He represents the people. Does he represent the party?
Okay, we're going to, that conversation is a bit, because there's even the part of what happens if it is a speaker that defects, who is supposed to give force to the defection. But there's another part that has to do with, there has to be an exhaustion of all judicial altercation or disagreement. The proposal now is that before you're sworn in, the court would have decided everything if your position or your mandate is challenged. I think this is a welcome development, don't you think?
It is a welcome development, and indeed, if we go by the number of days within which you should file petition 14 days, and the judgment must be delivered within 60 days, and what have you, and must want to appeal within a certain number of days. We can calculate those number of days such that elections are held, having consideration for this number of days before the swearing in, and we can get that done and put aside before election. We don't want to elect people, have them sit on the seats, and then we tell them, sorry, the court has said that you no longer occupy that seat. It's not right.
Okay, finally, the local government and state police. The police that's the biggest, perhaps the highlight of them all. It's been in the works. In your books, are we overdue for this? And also the fear. Governors have not done a great job at pitching for state police with the way they've conducted themselves in managing local government election that the federal government wants to now take over, in managing an arm of government, which is the legislature. Look at what is playing out in different states. So are we in for very turbulent waters, or we'll just take this risk on state and local government police?
It is up to us. It's up to us in the sense that I think this is a great opportunity for us to reconfigure, to redefine what policing should be in Nigeria. We have the Nigeria Police Force set under Section 214 of the Constitution, and these are people we have often criticized. We criticize the quality of the gentlemen who are in the police force. We criticize how they deal with civilians and what have you. Now, this is an opportunity for us to address that. If we have a police force now in the various states, it should not be under the singular control of the governors of those states. We should have a police force in a state where the qualification for even joining the police force should be very clear and a little higher than what we have now, so that people who join the police force will see themselves as professional men. If we have to, let us invite people who understand the whole idea of branding. Look, we are in a civilized world. We're in a world where things must now work interchangeably. Let people tell us what the psyche of the policeman should be. When he walks on the street, let people see him as a protector, not an oppressor. You remember in those days when we were young, we had lady police officers who would hold children by the hand and help them to cross the road. They held us by the hand like aunties and mothers, and we actually respected them. But you don't see that happen anymore. I also remember when we had the anti-riot policemen initially, they looked so smart in their uniforms until they also became, like they call them, kill and go. They began to become oppressive. But we still can show that policemen, whether in local governments, ensuring that they keep sanity in those areas, and they know that they are accountable to a police service commission, whether at the center or in the states, not to the governor, such that when the governor also does not conduct himself appropriately, they're able to walk up to him and say, Mr. Governor, but I'm sorry, what you have done today is wrong. But there shouldn't be an overlap. The state police officers should know what they should do, so that we don't have a situation where someone has committed an offense and the state policeman will say, oh, we have arrested him, don't worry, Nigeria Police Force, you back off, we'll get this done. So it's an opportunity for us to start a complete re-engineering.
Kayode Adelola is a senior advocate of Nigeria. Thank you, sir. There's a lot here, about 40 or more that we'll need to deal with. So it's an ongoing conversation, but must thank you for your insights and your perspective. Thank you, sir.
Thank you for inviting me. Thank you.
And that's it on the program. Thanks for your time and company. I'm Jeffrey Uzongo. You've been served on Lunchtime Politics. Bye-bye.